Let's say you're driving down the road and you get pulled over by a cop. The cop notices that you have a valid concealed carry permit. So he pulls you out of the car, handcuffs you, and searches your car because he claims that valid concealed carry permit gives him probable cause. Should he be protected by qualified immunity? Let's go ahead and talk about it. What's up, Wolverines? Welcome back to the channel. My name is John Crump. I'm an investigative journalist, and I talk about 2A every day. This is my channel, John Crump News, where you can get all the latest 2A news. If you can do me a big favor, you know the drill, like, comment, and subscribe. As you can tell, I'm not in Virginia. I'm not in Delaware. I'm in New York, where I sometimes do videos, and I'm doing videos here now. I'm here for a couple days before I head down to Tennessee. I'll talk about that in a second. But first, we are opening up for sponsors once again. And the money from the sponsors that I get will not go to me, it will go to the Cub Scouts. And it's to help these young boys become men and learn valuable skills that they can use throughout their life. If you're interested in sponsoring a video and 100% of the money will go to Cub Scouts, you can hit me up at info@crumpy.com. That's info@crumpy.com, and just put in the title, sponsor, Cub Scouts, or whatever you want to do. It will be great, and I would definitely appreciate it, and so will the Scouts. I also will be at the Goals event in Knoxville, Tennessee next weekend. That is the Gun Owners of America convention/conference, where you can learn a lot about 2A issues. There's tons of classes, there's tons of speakers, including the Big Red Machine Cane, which I'm really excited about. You can come out and meet me and just about every other creator on the YouTube platform. It should be a great time, and I am definitely looking forward to it. Remember, on Saturday night, if you go to Goals, you can go to a free concert by Easton Corbin, which is a nationally known country music singer. The case we're going to be talking about today is Basil Sakana versus Nicholas Andre Z. Jujewski. I'm not going to say that too often because Andre Z. Jujewski is a really hard name to say, so I'm not going to repeat it multiple times. But it was heard by 3 judges from the Second Circuit Court of Appeals up in the Northeast. And we're going to be talking about exactly what this case involves. And I'm thinking that you guys will be very interested and you guys will have a nice opinion on this cop. The incident that spurred this case took place on November 12th, 2018 at 8:43 p.m. in Waterbury, Connecticut. Basically, the plaintiff pulled over his car because his iPhone locked up. He turned on his dome light and was trying to fix his phone that was in a holder that was attached to his dash. The defendant in the case was the officer that saw him pulled over. This area is known for drugs and prostitution, although everyone admits that he wasn't there for drugs or prostitution. The cop went up to his window and demanded forcibly to see his license. So the plaintiff handed over his license. Not only did he hand over his license, but he handed over his firearms permit because he had the gun in his car. The permit was valid and the gun was totally legal in Connecticut. When the cop saw that, he freaked out. He forcibly pulled the driver out of the car, slammed him to the ground, handcuffed him, and threw him in the back of the police car. He then issued an order for him to shut the hell up and just sit there. The cop, for some reason, thought because this guy had a valid firearms license that he had probable cause to not only detain him, handcuff him, and throw him in the back of the car while roughing him up, but he also thought that he had the right to search the guy's vehicle. And that's exactly what he did. He searched it from front to back, trunk. No area was not overturned, and nothing illegal was found. Another cop showed up, and the cop that is the defendant in this case said to the other cop, "What should I write him up for?" Because they didn't have anything to write him up for anything because he broke no laws and this cop violated his rights. Well, he was set free and then he filed a complaint and sued the officer. The officer claimed qualified immunity and a district court rejected that for the search, not for the stop. They said that he had qualified immunity for the stop, but not for the search. Qualified immunity means that an officer cannot be held responsible for anything that happens in the line of duty as long as they did not grossly violate someone's rights. And I believe that this cop grossly violated the driver's rights, and so did the district court. So for the motion for summary judgment, the cop lost and the driver of the car won on the illegal search and seizure of the vehicle. The cop in question decided to appeal to the circuit court, stating that he should be protected with qualified immunity. Me personally think qualified immunity is a bunch of BS, but that is just me. I know there is a lot of different opinions on there, but if you give someone qualified immunity, they are more likely to violate your rights because they have less of a fear of prosecution. The appeal was argued in front of a three-judge panel in October of 2022. That's almost 2 years ago. And that's probably because the judges on the case were all liberals who don't like guns and they knew what they had to do, but whatever. In the oral arguments, the cop's lawyers tried to argue that the presence of the firearm gave him probable cause, even if that concealed carry permit was valid. The defense was mistaken here if they thought there was any sympathy from all three judges, because they did not. The plaintiffs in the case argued that beyond a Terry stop, anything else was not admissible and was a violation of Fourth Amendment protection. What the judges said was this cop instigated a de facto arrest. A de facto arrest is an arrest in all but name. There's a bunch of different criteria for an arrest, and this case checked all of them off. So even though the cop said you're only detained and you're not arrested, that's not the case. When you detain someone, you have to keep them for the least amount of time possible. You have to use the least amount of force. And this cop did not do that. He exercised excessive force and detained him for an excessive amount of time while he carried out an illegal search, which the court called out rightfully so. So the court said, since your violation of the driver's rights were so gross that you are not entitled to qualified immunity. You're still entitled to qualified immunity for the stop because he was stopped in a high drug, high prostitution area, but you are not entitled for qualified immunity for the de facto arrest and the illegal search. If having a concealed weapons permit or any type of firearm on you was grounds for probable cause for a search, then we would be in really big trouble, because you can still use the same argument and say, well, if someone is preaching something you don't like, I can search them because I don't like that. Even though that they are using their First Amendment rights, I can still search them because I do not like that, which is wrong, and you cannot apply a double standard to the Second Amendment. So the judges said that the district court's ruling for the plaintiff in the case and against the defendant's motion for summary judgment was correct. They have remanded the case back down to the district court to issue relief. We're not sure what that relief is going to look like yet, but I'll be interested to see. I cannot believe that this took 2 years from oral arguments to get back an opinion, but that is where we're at now. This is a good thing. I think we need to end qualified immunity. I know some of you will disagree with me out there. Some of you will agree with me, but in my opinion, qualified immunity is abused way too much. I get the idea of qualified immunity. I really, really do. But it is abused way too much. It is used way too much to strip someone of their rights. It is used way too much to violate people's constitutionally protected rights, and therefore it needs to go. That's just my opinion. You might disagree with me, but hey, it is what it is. All right, guys, that is it. I will see you guys in Knoxville if you are going to Goals. If you do go to Goals, let me know. I would love to meet whoever is there, and we can have a good old time down in Knoxville, Tennessee. All right, guys, that is it. So stay ever vigilant, stay ever free, keep it the fight. I am out of here. Wolverines and Meffers.